Ken, how are we doing in terms of a quorum?
Right now, we are one short. We have Commissioner Freeman, Vice Chair Bovet, and yourself.
Okay,
We just need one more to do business, but we should be
yeah,
seeing Lisa and Jeff Auxier come in.
great.
And Jessica confirmed that
Oh,
she
and
was
Jessica.
going to attend too.
Thank you, Carol.
Super.
And it looks like Commissioner Beach just popped in, so we have quorum to go ahead. It's still a minute before, so we can wait for the others, but just wanted to let you know that we are ready to go when you're ready.
Okay, thanks. All right, well, it's 1 o'clock by my clock. Let's go ahead and get started. I know we have a fairly packed agenda. This is the May 29th meeting of the Oregon Criminal Justice Commission. For the record, my name is Paul Solomon. I am the chair. And we will go ahead and get started. Ken, do we have anybody signed up for public comment?
We
don't
don't
believe
have
so.
any public comment. Oops, sorry.
No, it's
We
fine.
do
Thank
not.
you, Carol.
Okay. Well, let's jump right in. I see we have our friends from Clackamas County all ready to go. So looks like the first item on, yeah, go
Chair,
ahead.
would you like Carol to call the roll real quickly?
Oh, yeah, please. Sorry. Roll call.
No,
you.
no worries. Commissioner Auxier. Commissioner Beach.
Present, and my apologies, I'm having difficulty with my camera today, but I am here.
No worries. Vice Commissioner Bovet.
Present.
Commissioner Freeman.
I'm present today.
Commissioner McPherson. Commissioner Norton. Senator Przonski. And Representative Lewis. And then President Solomon.
Present. Thank you.
Thank you.
All right. It looks like Ian, you're going to take the lead on the Clackamas County GRGP award.
Yes, I'd be happy to do that. For the record, Ian Davidson, I'm the Justice Reinvestment Program Manager. And so this presentation today, I'll be providing an overview of Clackamas County's responses to their second year funding application, and then the Grant Review Committee's recommendation to award them second year funding. So as a reminder, the Justice Reinvestment Program approval process is a little bit different than some other grants that you all review and approve. For you all, the Justice Reinvestment Grant Review Committee makes a recommendation to you, and then you have one of two options. You can either approve their recommendation, or you can return to the committee for reconsideration their recommendation. And if you do, it goes back to the Grant Review Committee, at which point they'll make another recommendation, and then we start the process over again. So that is a quick overview of the Justice Reinvestment Program grant funding approval. So Clackamas County, when they were awarded 1 year provisional funds, the Grant Review Committee and then you, the Commission, approved a set of questions that Clackamas County needed to respond to. There are 3 questions. I'll read through them briefly now. The first one is to conduct a review and thoroughly explain the programmatic reasons for the lack of a decline in prison usage over the last decade. Second, to conduct a review and explain the programmatic reasons for the recent increase in property crime intakes. And then last, it's to provide an update on the efforts being made to provide culturally responsive services and what actions have been taken following the recommendations of the 3-year study completed by county partners, as mentioned in your final application. As you can see here, these questions ask them to explain some things. Clackamas County, I'll note, they not only explained what was occurring, but have also detailed an action plan on many of these different efforts, which I'll outline here. So that first question asked about a lack of decline in prison usage over the last decade. I won't, try and be comprehensive in conveying what they said in their application, but I will highlight a few things. The Clackamas County did note in their application that the reasons for the lack of reduction are layered and complex. And they also said that public safety in the Portland metropolitan region could better be viewed as an ecosystem that sprawls across jurisdictional boundaries than something that neatly fits into lines in a political boundary. And as a result, there are some regional impacts based on their geographic location with proximity to Multnomah County as well as Washington County. They've identified some barriers to their substance abuse program, which they call CSAP, and they've identified some opportunities for improved collaboration with public safety partners. They've outlined a few steps that they plan to take to address prison usage. First and foremost, they plan to use Justice Reinvestment Program funds to expand a program called the Clackamas County Jail Program. This would provide low barrier services in the form of cognitive behavioral interventions for individuals currently in custody in the jail. This will result in 2 new certified alcohol and drug counselors and will expand opportunities to evaluate and engage individuals while in custody. This new jail program will, quote, further assess individuals prior to decisions related to sentencing or in conjunction with a downward departure sentence. It would also create new avenues for eligible individuals to successfully transition from local incarceration into CSAP. They've also mentioned that their local district attorney's office, as well as community corrections, will be doing a review of performance metrics within existing justice reinvestment programs with a focus on downward departure sentences in particular. They noted that this may result in a redesign of the process of evaluation and screening for individuals who might be eligible for placement into a justice reinvestment program. They also noted that the evaluation reports may include a more detailed and holistic review of an individual's history, criminogenic needs, and suitability for a departure sentence.
Ian, can I ask a quick question?
Please.
So does Clackamas County not receive any of the competitive JRI funds that are used for downward departure programs?
That is correct. Clackamas County has not received competitive funds.
Okay. Thanks.
Yep. The second question, they dealt with an increase in property crimes recently. So they noted that the existing system of governance is not designed to provide services for a prison-eligible population with an out-of-county residency. And so they acknowledged that, but then they identified a plan of action. They intend, Clackamas County Community Corrections Division, they intend to work more closely with Multnomah County's Department of Community Justice on cases involving Multnomah County residents. So what this might look like is that they would perhaps, after consultation with Multnomah County, have a Multnomah County resident begin participation in CSAP and then maybe transfer out to Multnomah County, but having a warm handoff process. So instead of treating them simply as an out-of-county resident, there's a plan of action to where you can hand them off to Multnomah County and avoid a prison sentence, which is what would happen otherwise. Then the last question was around culturally responsive services. They noted in their final application that there was a 3-year study going on. That study has not yet concluded. They're in the final stages of reviews, but they anticipate a series of recommendations to be delivered to the county shortly. Once those recommendations come, the LIPSIC intends to review that, or at least the material that is relevant to them. And then they individually, both as those member agencies of the LIPSIC, but also collectively, will identify ways that they can improve the provision of culturally responsive services. However, instead of just waiting for the recommendations, they have recently taken some actions that they identified in their application. First is they are working to increase fidelity of behavior change plans across diversion to account for different responsivity factors, including gender, trauma, race, and culture. They're also working to identify ongoing equity trainings for probation officers. They're in communication with the Department of Public Safety Standards and Training, looking at those training opportunities. They've also reworked requests for proposals for their largest contracts to require service delivery to include evidence-based and culturally responsive provisions. The District Attorney's Office has recently established an advisory panel comprised of community members to help inform prosecutorial practices. And then they are conducting a review of client-facing documents to ensure that they are translated into the county's safe harbor languages. And that list of languages is far beyond what just English and Spanish. And so that is a very brief summary of Clackamas County's application, the response to the questions, and then I'll just conclude here by saying that the Grant Review Committee unanimously recommended second-year funding for Clackamas County. And I'm happy to take any questions.
Thanks, Ian. Questions for Ian on the Clackamas County request? Any discussion? All right, I would entertain a motion if someone would like to make one.
Mr. Chair, I would move to approve Clackamas County's proposal as just outlined by Ian.
Great.
I'll
We
second.
have,
Sorry.
motion- Yeah, no, go ahead. That's great. Motion made by Vice Chair Bavette, seconded by Commissioner Norton. Lisa, would you mind taking, or Carol, would you mind taking roll?
Yep. We'll start with Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovett,
Yes.
Commissioner Freeman,
Yes.
Commissioner Norton.
Yes.
So then it passes.
Great. Thank you. Get the agenda back up. All right. Next up, we have Washington, Columbia, and Clatsop. Are we going to go in that order?
Yes.
Ian? Okay, great. So let's start with Washington. We had a robust discussion last time. I know that Washington County did quite a bit of work to rework their proposal. So look forward to your analysis, Ian.
Happy to do so. So as Chair Solomon just mentioned, this is Washington County's most recent adjustment request. This reflects changes that they made in response to discussion that you all had in your March meeting. The new adjustment request is a scaled back request, which provide both additional details and assurances. They are requesting the financial impact is actually half of, actually more than half, less than half rather, of what they were requesting in March. And so they are proposing to move $238,000 to cover an additional one full-time equivalent deputy district attorney. This will bring their total JRP funded deputy district attorneys to 1.5 FTE. This would put them with the same number of JRP funded deputy district attorneys as both Multnomah County as well as Josephine County. And it would make them equal, they would have fewer than Josephine County and Multnomah County, and it would make them equal to Douglas County's JRP award. The funds that they intend to use to make this movement of funds come from mentor services, housing, GPS Scram, and then substance abuse testing services. Washington County has indicated that they will be allocating other funds, so simply just not Justice Reinvestment Program funds, to ensure that there is no impact to these services. That concludes my report on Washington County's adjustment request.
Great. I spent a bit of time looking through their proposal and feel like it is much better detailed than the first request. I'm open to having a discussion on this, or we can move straight to a vote. Commissioners.
I would move to approve this adjustment request from Washington County.
All right, we have a motion. Is there a second?
I'll second that, Commissioner Beach.
All right, we have a motion on the table by Commissioner Auxier, seconded by Commissioner Beach. Carol, would you take the roll?
Of course. Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
I will abstain, not due to legal conflict, but just because I work for Washington County.
Commissioner Freeman,
Yes.
Commissioner Norton. Yes. It passes.
Great. All right, well, we're moving right along. Next up is Columbia County.
Okay. Columbia County's adjustment request, they're requesting to move a little more than $200,000 to pay for the following items: electronic monitoring, new position, which would be, an intervention specialist position. This is increasing the budget. Long story short, they miscalculated how much this position would cost when they initially submitted their biennial budget, and so this is backfilling that. And then the third item is an administrative case specialist. This is a new position. These funds are currently being paid for a pretrial release specialist and pretrial software. Columbia County, like a handful of other counties, their local circuit court is taking over pretrial operations, and so JRP funds are no longer needed to pay for pretrial program operations. In addition, funds that currently pay for prorated rent and security deposit supports and then treatment services are being moved or proposed to be moved around. I had a lengthy conversation with Columbia County about those particular movements, and they have assured me that those that the reduction or the proposed movement of funds from both treatment as well as housing will be backfilled in the event that the requests exceed what they are projecting. They have indicated that the budgets that they submitted for this current biennium for both prorated rent and security deposit supports as well as treatment services far exceed what is now being utilized by justice involved individuals. It appears that Medicaid funded programs locally are covering the bulk of the treatment cost services, and so the county through justice reinvestment funds are no longer needed to the same extent that they once were. And similarly, a community action agency that's based in Columbia County is covering the bulk of the prorated rent and security deposit supports for JRP clients. And that concludes my report on Columbia County.
All right. Any questions for Ian or discussion on the Columbia County request? If not, I would entertain a motion.
Mr. Chair, I would move to approve this Columbia County adjustment request.
Great. Is there a second?
I'll second, Commissioner Beach.
Right, we have a motion made by Vice Chair Bovet, seconded by Commissioner Beach. Carol, would you please take roll?
Yes. Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
Commissioner Norton.
Yes.
And then it passes.
Great, that brings us to Clatsop, the last of our adjustments. You're on mute. There you go.
Thank you. For Clatsop County, their request is very straightforward. Like Columbia County, their pretrial program is being taken over by the local circuit court. However, it is not being taken over just yet. And so what Clatsop County has experienced is that with retirements and then departures, there's now vacancies in the county-based pretrial release specialist positions, but they don't really want to fill those positions because those positions are going away. So what they are proposing to do is move the remaining funds that would have gone towards a county-based pretrial release specialist to instead temporarily funding OJD-based release assistant officer position. As they note in their adjustment request, the only change to the program is the title change in employer. So they're functionally the same role, different title, different employer. But the services are the same. It's just a movement from personnel to contractual and from county to OJD.
Great. Any questions for Ian? Is there someone that would like to make a motion?
Mr. Chair, I'll make a motion to approve the Clatsop County adjustment request.
Is there a second?
And I'll second that. Commissioner Beach.
Thank you. All right, motion made by Vice Chair Bovet, seconded by Commissioner Beach. Roll call, please, Carol.
Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
Commissioner Norton.
Yes.
And then it passes.
Wonderful. All right, I think that moves us into our discussion about specialty court grant. And
Chair Solomon?
Yep. Oh,
If I
Go
could, could I make one additional request?
yeah, please. And I see Commissioner Norton has her hand up too. Go ahead, Ian.
Okay. So as you just saw with Clatsop County, there was a request, and we've now seen a handful of these requests of adjustment requests specific to pretrial programs because of the changing landscape of how pretrial programs are funded across the state. In many counties across the state, the Oregon Judicial Department is taking over operations of that. And so some JRP funded programs are changing. And so my request today is that the commission delegate limited authority to allow staff to approve adjustment requests as they come in, dealing with pretrial programs, however, with some conditions. The first and most significant would be that this would only impact adjustment requests that deal with exactly what you saw with Clatsop County, which is a movement of a county-based pretrial position to a circuit court funded position where the duties are substantively the same. If this were to not be a movement between different branches of governments or personnel to contractual, this would normally be something that CJC staff would approve, but we're making this request. And we would not, however, approve or be given authority to approve something like Columbia County's request, which was a movement of pretrial to something completely different. And then in any event, if we were to approve any request like this, we would update you at future commission meetings of that action taken by staff.
Great. Commissioner Norton, you had your hand up for a second. Was there a comment that you wanted to make before I go to Commissioner Bovet?
Yeah, thank you. It was Ian kind of answered it. It was like, why are we, because I'm new on the commission, it was just a question of like, why are we getting all of these requests? Because I could see, and a trend possibly developing. So Ian's kind of addressed it, and that was all I was going to ask about. So thank you for the time.
Yep. Vice Chair Bovet.
I just have a real quick question for Ian, and I'm sure you've already looked at it, but is there anything in our rules or our grant solicitation that would preclude us from delegating this limited authority? I'm all in favor of it. I know what's happening right now, in the counties and with OJD. So that your recommendation makes perfect sense to me. I just want to make sure we're not running afoul of any rule we have.
No, there's no rules or anything in our solicitation that would preclude you from delegating this authority.
Great. Unless there's further discussion, I'd be happy to make a motion to approve that recommendation from staff.
Yeah, that would be great. Well, actually, any other
see.
discussion, thoughts about this? Seems like a fairly straightforward, narrow request that makes a lot of sense to me. So, okay, we have a motion from Vice Chair Bovet to approve staff's request. Is there a second?
I'll second.
Right, seconded by Commissioner Norton. Would you please take roll, Carol?
Of course. Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
Commissioner Norton.
Yes.
Then it passes.
Great. All right, anything else, Ian, before I move us on to the specialty court grant discussion?
I did
Allocations?
just want to note, I should have made this more clear, but with the Clackamas County's request, it included a creation of that new Clackamas County jail program, which I detailed. I just wanted to make certain that you were all okay with that as well.
Yeah, was there something that you thought we might have missed about?
No. I just realized that I didn't specifically flag that this is a new JRP funded program. It's a previously funded program. It's just now
Got it.
JRP funds from pretrial are moving to that.
Okay,
Okay. Thank you.
thank you. Mhm. All right, Adeline?
Hi, everyone. For the record, I am Adeline Padlina, and I'm the Specialty Court Grant Program Coordinator. Excuse me. And today we are going to be talking about some funding decisions regarding House Bill 5204. So, as I'm sure you're all familiar, thanks to the passing of House Bill 5204, roughly $6.9 million was appropriated to the Specialty Court Grant Program for county use. So this is super exciting. The direction for this funding was towards use to the same grant applications, and it was prorated for distribution starting in April of this year. We, being the CJC, asked counties to submit modified specialty court budgets. So again, the intent of this funding was to restore or increase items that were requested during the initial grant process of the 23-25 biennium, but that we were unable to fund because the CJC's budget limitations. If you remember, we cut about $9 million. So this ideally was going to refund some of those requests that we didn't have funding for. However, we did recognize that some counties, because of those cuts, might have changed direction. So we did allow new requests. However, those should have been limited to items that were critical to the court's adherence to standards. So what we didn't want to risk was providing funding and having their scores go down, if that makes sense. And then, of course, requests for unallowables. So if it's not allowed in the grant administration guide, we didn't overrule that. We did have a couple, I think through some confusion, request more money than they were allocated. So we didn't allow that overage. And then for non-county positions, because again, the guidance from the legislature was that this should go to county positions. So what I have done is there are 53 of these, and I figured you didn't want to go through 53 slides. So I have put them in tables based on the specialty court type So for our adult drug courts and our mental health courts, there's a couple slides. For the other court types, they'll all be in one slide. My thought was that you all could review them, and I will anxiously and quietly sit here. And then if you have questions about why specifically recommended funding looks different than requested funding, I can elaborate on that. Does that sound good to everyone?
Great.
Let's do it. All right, so here's our first chunk of adult drug courts.
Can you address the funding request from Jefferson County?
Yeah, of course. So they requested $30,396.56 over their allotted amount. So we reduced it to match the allotment.
Okay, that's what it looked like, but thank you.
Yeah.
Questions from commissioners? Can we move to the next slide? Let's
Thank
move
you.
on.
I've stared at these for several weeks now, so I don't know what the appropriate amount of time is.
Mhm. So I'm recognizing that there's more available funds than actually being what's being requested.
Yeah.
So will there be a supplemental round at some point?
That is the current plan. So we're waiting for OJD to move the funds over. That's just taking a little bit of time. And then we also needed approval on these adjustments, obviously. So once we get those items in place and we have a set amount, then we can look at when the best time for that supplemental round will be and if it's needed.
Okay.
Shall I move on to mental health courts?
Please.
All right. So here's our first batch of mental health courts.
Okay.
And our second part.
Wow. Again, looks like there's going to be a bit extra money there.
Yeah, I really want to compliment the courts. I think we're really cognizant of underspending, which has been something that has commonly happened in the past with specialty courts. And so I think there was a pretty big focus on how can we utilize the funding that we need, but then make sure any leftovers available for other counties or other courts that might need it as well. There were actually a couple courts, you'll see them as we go through, but that also didn't request any additional funding for various reasons.
Mm-hmm. Okay.
These are our family treatment courts.
Okay.
Just
Question?
the big difference in Harney and Josephine, can you explain those?
Yeah, so they requested a hearings referee, which is an OJD position. So that was about $70,821.80.
Okay. Next slide.
These are our veterans treatment courts. So just the two of them. You'll notice that Lane was one of the ones that didn't request any additional funding. And then these are our juvenile treatment courts.
Okay.
And then finally, we have our DUI courts.
Do you have a rough total of the net that you'll have left over?
I do. Let me see if I can can you all see that?
Yeah.
Perfect.
So, wow, like 1.7 roughly.
Yeah.
That's great. Not to mention, I'm thrilled. This was one of the things that came out of 5204 that I think pleased many of us on the commission to see specialty court funding restored to at least make up the difference between what was requested and what counties received. As we've complained for a long time, the soup keeps getting thinner and thinner. And moving the treatment court coordinators to OJD will also have a profound effect moving forward. So I feel very good about the legislature's recent move to more fully fund our treatment courts, our specialty courts.
That feels
Alright,
like
so-
a good, oh,
yeah.
sorry.
So we need to vote on these.
Yeah, and I knew that there was a history of abstention, so I
Yep.
provided some language for you all, but
Great.
no pressure. If you don't like it, you won't
Yeah.
hurt my feelings.
I love it. Okay, so it looks like the first is a motion to approve the additional funding allocations to all specialty grantees as presented, except for those in Douglas, Lane, Multnomah, Washington, and Yamhill counties. And it looks like we have commissioners present from all of those counties. So let's start there. Is there someone willing to make such a motion?
Mr. Chair, I'll just stay consistent. I'll make that motion to the top motion there to approve all the recommended funding allocations with those 5 exceptions.
Great. Is there a second?
And I'll second. Commissioner
Uh-huh.
Beach?
Great. So motion made by Vice Chair Bovet, seconded by Commissioner Beach. Carol, would you please take roll?
Of course. Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
and Commissioner Norton.
Yes.
So then it passes.
Great. Now we'll go through and individually approve the 5 counties that we pulled out, starting with Douglas County. Is there someone who'd like to make a motion to approve the additional funding allocation to all specialty court grantees in Douglas County?
Commissioner, or
Oh, go ahead.
Chair Solomon, I would so move.
Okay, great. Is there a second?
And I'll second that motion.
All right. Motion made by Commissioner Norton, seconded by Vice Chair Bovet. Roll call, please.
Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Like to abstain, please?
and Commissioner Norton.
Yes.
Then it passes.
Right. Next up is Lane County. Is there someone willing to make a motion to approve the funding allocation to specialty court grantees in the county of Lane?
So moved. Commissioner Beach?
Great.
Commissioner Norton seconds. Can't let
All right.
Commissioner Bovet have all the fun.
All right. Motion made by Commissioner Beach, seconded by Commissioner Norton. Roll call, please.
Chair Solomon,
I'll abstain.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
Commissioner Norton.
Yes.
Then it passes.
All right, moving on. We're at Multnomah County. Someone like to make a motion to approve the additional funding for specialty court grantees in Multnomah?
So moved, Commissioner Beach?
Is there a second?
Commissioner Norton seconds.
All right, motion made by Commissioner Beach, seconded by Commissioner Norton. Roll call, please.
Chair Solomon,
Yes.
Commissioner Auxier,
Abstain.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
Commissioner Norton.
Yes.
Then it passes.
All right, moving on to Washington County. Is there someone like to make a motion to approve the additional funding for specialty court grantees in Washington?
I will make the motion to approve the Washington County Specialty Court additional funding.
Great. Is there a second?
And I'll
I'll second.
second.
Oh.
Ooh.
All right, we'll take Commissioner Auxier's second since he hasn't joined the fray recently. All right, we have a motion made by Commissioner Freeman, seconded by Commissioner Auxier. Roll call, please.
Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Abstain.
Commissioner Freeman,
Yes.
and Commissioner Norton.
Yes.
Then it passes.
All right, last on our list is Yamhill County. Who would like to make a motion to approve the funding for specialty court grantees in Yamhill County?
I'll make that motion.
Is there a second?
I'll second that motion.
All right, motion made by Commissioner Auxier, seconded by Vice Chair Bovet. Roll call, please.
Chair Solomon,
Yes.
Commissioner Auxier,
Yes.
Commissioner Beach,
Abstain.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
Commissioner Norton.
Yes.
Then it passes.
All right. Anything else, Adeline, regarding the specialty courts?
No, thank you all.
Yeah, thank you. All right, that brings us to our Burn JAG funding request from the OHSU Gun Violence Review Commission. And I believe, Ken, are you going to tee that up?
I am more than happy to. I don't see our folks from OHSU on yet. We're a good 10 minutes plus ahead of time. And so I have sent them a message, but it might be worthwhile. I think that if it was okay with you, Chair, we could maybe move into the sentencing rule changes while we wait for them.
Yep, let's do it.
Chair Solomon, that is me. So just give me one
Great.
second to
Mhm.
get everything set up.
Pull it up in my packet here. Oh, it's at the very top.
Can you all let me know when you can see this?
Yep.
Perfect. Okay. So for the record, I'm Rachel MacArthur. I'm a policy analyst for CJC. So today we're just going to go over some sentencing grid modifications for the 2023-2024 sessions. If you'll remember back in December, you all went over some modifications that were needed from the 2023 session. We do have one section that is part of my presentation where I'm just going to ask for clarification on part of what you all went over in the 2023 session, which is why it is in here. It's just a very small part though. So I just wanted to clarify that. I'm not going to spend a lot of time on this part. Some of this hopefully is a little familiar from what you all went over last time. But you all have the authority to go over and modify sentencing guidelines that come out of each session. we use a presumptive sentencing grid that is known as a sentencing guidelines grid. And so this is what it looks like. And so the colored squares, just to go over this really quickly as a review, indicate an individual's presumptive prison sentence based on where their criminal history intersects with the severity of the most serious charge at issue. So in reading this, it would tell you that folks with a grid score of A11 have the most severe criminal history and the most serious crime severity ranking possible. And so that's how you read this. And so your all's authority comes into play. Oops, sorry, I missed my animations on this. So that might help you a little bit more with this review of what this grid actually looks like and how to interpret it. And so you all have the authority to review any new legislation that creates a new crime or modifies existing crimes, and shall adopt any rule necessary for modifications to the crime. And then this is kind of a little bit of a different process. Whatever the CJC staff does submit as rule is then goes to the Legislative Assembly for approval. And so there is an extra step after we do submit these modifications to the rule. And so the two key determinations for new or modified crimes are crime seriousness rankings, which we are going to talk a little bit about today, as well as person crime designation. And so you all have the authority to decide both of those. And you all are considered the experts in terms of deciding whether or not either is appropriate for new crimes or crime modifications. So I went over that kind of quickly because I do know that you have seen this before, but anybody have any questions before I move forward? Okay. So this is a little bit of the timeline. We are today discussing these changes. We would then submit those rules in and provide notification to interested parties. It does go through the same process as rulemaking, and so there is a minimum public comment period of 49 days. Once that is done, we can then submit for permanent rulemaking unless there is any sort of changes or anything that we need to modify or any feedback that we get from you all. Which then, if that's the case, we can come back with any sort of changes, get approval from you all, and then the legislature may enact those crimes or modify others based on your all's feedback. And so this is what we are going to be covering today. I kind of broke these up and Chair Solomon, this was the order that I was going to go in. We do have some that are more or less notifications. There's an unlikely need for any sort of grid modifications, but we do want to inform you all of any changes or those new crimes that came in. I was then going to present possible grid modifications. Particularly the delivery of marijuana is the one from 2023. So there possibly the 2023 session. So there could possibly be some discussion around that. Also possibly some discussion about consuming controlled substance on a public transit. And then the last one, there is a need for grid modifications. And so I know we kind of went out of order with the agenda. So I'm not quite sure time-wise how you would like me to proceed, if this is okay, or if you'd like me to move ahead to some of the more robust possibly the more robust discussion points. I think you're muted, Chair Solomon. Sorry.
Well, we need to go through all of it today, so let's correct.
That would be great. Yes.
Yeah. So let's go ahead and start right here.
Okay. Perfect. So these ones there's likely no necessary modifications. The visual recording of animal abuse, there's no change to the statutory requirement that is ranked as a crime category 7. It's the stalking, HB 4156. There's no change to the crime category, and it is already designated as a person crime. And then abuse of a corpse as a sex offense was in addition to the list of sex offenses and already a person crime and already ranked. And so no action needed from you all on these changes.
Okay.
And then, like I said earlier, the delivery of marijuana, which was discussed in the December commission meeting. We just need clarification, which I will get to in just 1 second. And then the consuming of a controlled substance on a public transit, it adds that consuming controlled substance on a public transit vehicle to the conduct that could constitute the offense of interfering with public transit. And so these two possibly have some action that is needed. So for this one, the last time that you all met and this was presented to you, the discussion was really centered around the crime category 8 designation. If the conduct was related to labor trafficking, you all made that decision pretty clear. However, in that discussion, there wasn't any clarity that in general, this is a crime category 6 designation for this particular crime. And so we just need some clarification that's where you all want that to land, is that crime category 6. And so in general, this is ranked as a crime category 6 with the exception of it moving to a crime category 8 if the conduct is related to labor trafficking.
All right. Looks like we got a question or comment from Vice Chair Bovet.
So as the primary author of this particular piece of legislation, I don't think we have authority to change the CC6 or the CC8. That's in statute. I think the only question is whether or not, to me, the only question is whether or not the CC8 in particular should be a person crime. I believe it should. The CC6 is really about, and then this is an enhanced crime for causing basically a lot of environmental damage. I don't think the CC6 would be a person crime. When it gets to a CC8, that means people are actively engaged in labor trafficking at these large illicit grows, mostly in Southwest Oregon. To me, that's a person crime. So I would say the CC6 non-person, CC8 person. That's just my take. I'm just one member of the commission, but we don't have any discretion about the 6 and 8 itself.
Yeah. Great. So we're really just talking about whether we make the CC8 a person felony.
Chair Solomon?
Yeah.
If I may, that has actually already been decided. What Vice Chair Bovet just did was differentiate between the two, which is the information that we actually needed in that clarification. So
great. Wonderful.
If you're good with that, then
Yep.
we can move on. We just needed some language there that we could rely on when we actually modified this rule. So perfect. Okay, moving on. And so this is SB 1553, which is an amendment to the crime of interfering with public transit. So this particular bill adds consuming controlled substances on a public transit vehicle to the conduct that could constitute the offense of interfering with public transit. If the individual is engaging in this conduct, has 3 or more prior convictions for interfering with public transit, then the offense is a Class A misdemeanor. And so just essentially the consideration is a possible designation of a person crime, either in whole or in certain situations, for you all to consider.
Can you provide a little more context as to why this might be a person crime? Because I'm not quite seeing it.
And Mr. Chair, if I could comment on that. I'm not saying I support this notion, but the legislature did differentiate between this particular offense, which doesn't go into effect until January 1st of next year, and essentially the recriminalization of possession, which occurs in September 1 across the board. They focused on this because there was a lot of testimony and a lot of complaints about mass transit and the exposure of people on essentially mass transit trains to fentanyl smoke, needles, this type of stuff. I think somebody might make out an argument that, well, that's really affecting other people directly. But to me, that's an indirect person crime. And I'd be very interested in what Commissioner Auxer's take is. But in terms of the rubric of how the actual sentencing guideline grid work, I don't know that it makes sense to have this be a person crime.
If I could weigh in too, I wonder just, I think there's conduct here that's just really worthy of criminal prosecution, right? Like when someone is really disregarding, other innocent passengers and using incredibly dangerous toxic chemicals right around, you can imagine, really aggravated situations here. I think in those situations, there are probably other person crimes you could charge, like reckless endangering or things like that, in order, and where you would probably charge this interfering with public transit in conjunction with other counts that address that that there's a real victim. So I don't think, I kind of agree. I always open up the Secretary of State OAR page and look at the lists of person misdemeanors and person felonies right now contained in the Oregon Administrative Rules. And I think that would be a little outside of the norm to consider this a person misdemeanor.
I tend to agree on both counts. Any other commissioners have other feelings or thoughts about this? Yeah, Commissioner Norton.
So I guess my only concern is, while it's possible, is it not just theoretically possible, but is it in practice possible to charge other crimes? You see what I'm saying? Do you see the difference? Like, I could charge attempted murder, but is it likely I'm going to charge attempted murder type? And that's a way bigger than this, but because in my head, I'm like, yeah, there's a person that maybe does, I'm trying to use appropriate language, like does cocaine, like in the back of the bus. That's probably not going to harm somebody versus somebody smoking meth or fentanyl where the fumes. And so for me, I know that seems very in the weeds, but I also wonder, I also don't like the idea of like, oh, we could possibly charge them with other stuff and then it come back and go, oh, no, that's not ever going to happen because we never use that law or something like that. Again, apologies in advance. I'm not a lawyer or in the legal field.
Commissioner Bovet?
Actually, Commissioner Norton, the two examples you gave are perfect examples. It's been, slightly over 10 years since I've been an elected DA, so I defer to Commissioner Auxier as well. But in those two examples, I think you point out the fact that in one case, you really are recklessly endangering someone else, and in the other, you're really not. So I would say yes to your fundamental question. It's very fact dependent.
Commissioner Freeman.
Thank you. And you guys probably know what I'm going to say, but I understand this is you have to have had 3 prior convictions. So you've had 3 bites at the apple not to do drugs on public transit before we're talking about this. So that's 3 previous times you've possibly endangered another person. I think it's absolutely a person crime to have people doing drugs right next to you on a public transit and possibly exposing you or your children to it. So again, I might be the odd man out on this, but again, this the way this law is structured, it gives people lots of chances to get their stuff together before they're in trouble.
Thank you for your comments. Other thoughts? See, we've got a hand up somewhere. I can't see who it is though. Oh, no, I guess that was Commissioner Freeman. All right, so Rachel, at this point, you're looking for us to make a decision about whether to classify this as a person crime or not, correct?
That is correct. And if you remember last time in December, I believe it was just a consensus is how you all
Okay.
came to it, and just giving us guidance on what we need to do as staff when we submit this. So
Yeah. Well, given my understanding of person crimes that are in statute, this does not really match up. I would not be inclined to want to classify this as a person crime, particularly when there are other ways to charge people who are engaging in what could be pretty reckless behavior. Can we get a consensus on which way we want to go here? We've heard from, I think, all the commissioners on the call, but if we could just do a quick check-in. Could I start with you, Commissioner Bovet?
So I could see the argument being made out, and I actually agree with Commissioner Freeman as a kind of social matter, but I also have experience as an elected DA and working with the sentencing guidelines grid. So I just don't see this one fitting into the rubric of the panorama of crimes that we've already painted on. So, and I believe we can, in fact, charge a person crime, reckless endangering, or even a higher level crime if the facts bear it out. So I think my take is we leave this as a non-person crime, but that's just my take.
Yeah. Commissioner Auxier?
I echo Mr. Bovet's sentiment.
Great. Commissioner Norton?
Okay. I think I would concur just because you could charge it. Yeah, I would concur.
Okay, and Commissioner Freeman, to be clear, you're in the person camp.
Yes, Mr. Chair. Thank you.
Okay. Great. So it sounds like we have consensus to not classify this as a person crime. Do you want to move on to the next item?
sure. Yes, thank you. And then the last one is HB 4043, and it's interfering with an investigation of offenses against animals. And it is currently not classified as a person crime, and the crime seriousness ranking is needed if it is a felony. And so this is kind of broken up into two parts. If it's a Class A misdemeanor, if someone has a prior conviction, it may be a Class C felony. If it is a Class C felony, then, sorry, I apologize. Then it is a crime category 7. So one of the considerations is a designation of a person crime for that first part. And then the amendments to the crime of aggravated animal abuse is currently a Class C felony with a crime seriousness rank of 6. And we, CJC, must rank it as a crime category 7 when certain factors are present. And essentially what that is in part of the bill, it does talk specifically about if there are any offenses that are similar to or equivalent to those laws in another jurisdiction. And so that particular amendment also needs a designation of a person crime.
Okay, again, I'm gonna need some help here. It seems like an animal's an animal and a person's a person. help me understand why we might consider abuse of an animal a person crime.
I was looking at the Oregon Administrative Rules, and it seemed, according to the CJC, animals are people too, from what I can gather.
Really?
Looks like there's a lot of precedent for that.
Okay. Go ahead, Commissioner Norton.
So, yeah, I guess my thing is it's the issue of interfering, right? Or did I miss that? The interfering. So I could see that point being because you have to do something against a person usually I'm just going to shut up. I could see because the action might be against a person, whether it's seeking to intimidate somebody or something like that. But that's where I could see it. If that makes, I don't know. I'm sorry. It was in my head. It made sense.
Yeah, great. It looks like we've got Commissioner Freeman on deck, followed by Commissioner Auxier.
So, Mr. Chair, I agree with you. I doubt there's anybody out there that, loves their animals and pets more than I do. However, animals are animals and people are people. The designation of a person crime should be about persons and people. And this is a stretch for me.
Thank you. Commissioner Auxier. You're muted.
I take the opposite position, in part because what I think one of the goals with designating crimes as person crimes, person felonies, person misdemeanors, is that it carries a lot of weight for if you have person misdemeanors, person felonies on your record, you are going to move up the sentencing guidelines grid in a way that increases the likelihood, or at least increases the judge's ability to send a defendant to prison and have that option if subsequent person crimes are committed. And I think that the logic that apparently if I were to speculate as to what the CJC was thinking in the past when it designated other animal abuse offenses as person crimes, was that people who commit these crimes, if you have these kind of crimes on your record, it's a pretty serious predictor of future lethality and future violent conduct. And so I'm a pretty enthusiastic supporter of making these crimes designating them person crimes, because it simply gives the judge an option when to incarcerate someone when that's the best thing to do for public safety.
And I know Commissioner Freeman has his hand up, but before we go there, I have a question for you, Commissioner Auxier. You had mentioned that there's examples in statute of other animal crimes being person crimes. Can you provide some more context there?
Yeah.
Chair Solomon, if I may just jump in real fast and kind of add to Commissioner Auxier's just previous comment. Sorry, Commissioner Auxier, I didn't mean to interrupt you. But you were referring to previous crimes. The bill, especially the amendment to the crime of aggravated animal abuse, does refer to assault in the 4th degree, assault in the 3rd degree, assault in the 2nd degree, and assault in the 1st degree. And so those are the other types of crimes that are referred to that have to be present in order for it to be categorized as a crime category 7. So that, I think, is kind of what Commissioner Auxier was referring to in terms of a grouping in crimes that were similar. And I just saw Ken raise his hand, so he may be able to be a little bit more eloquent about what I just said. But I believe that is what Commissioner Auxier was trying to point out.
Commissioner Freeman, are you okay if Ken opines here real quick? Great. Go ahead, Ken.
And it's not so much opining, it's just to make sure that all of that detail is present. So the crimes that Rachel just mentioned, those are, like she mentioned, what would elevate misdemeanor animal abuse to this felony level. But it also makes it also is required that it's only when those offenses involve domestic violence. And so I think that's why this is kind of the question we're raising here. I would also point out that you can also get to the felony level when you knowingly commit animal abuse in the immediate presence of a minor child. And so that's why we were raising these. And I think they do go to what Commissioner Auxier was mentioning. I just wanted to make sure that those pieces of information were just very clear to you commissioners as you're making this this decision. And I think the other animal abuse related crimes that we have in our person crimes designation from the past, they're related to these types of situations as well. We're not talking about simply abusing an animal as noxious as that would be. It's when it is involved either in a domestic violence situation or again in the presence of somebody who, given their impressionable age, could be really harmed by that.
Well, that context is very helpful. Commissioner Freeman and then Commissioner Bovet.
So thank you for that context, and Commissioner Auxier, thank you for your input on that. You've convinced me that I was wrong and this should be a person crime. That being said, the indicator of animal abuse and future crimes is absolutely, there's a connection there, and we've seen that in a variety of ways. I would maybe contend that using drugs on public transit might be an indicator also, but we're past that now. So anyway, I agree with you and would support making this a person crime.
Great, thank you. Vice Chair Bovet.
Thank you, Chair Solomon. Just a clarifying question for Ken, because I know this came up. It's been a few years since it came up. So what you're telling me, and I'm trying to go through the rules here real quick. What you're telling me is that animal neglect and animal abuse as misdemeanors are currently treated under our sentencing guidelines as person crimes, without any aggravating factors, just straight animal neglect and animal abuse.
I believe so. Yes. For the misdemeanor, I've been looking mostly at the felonies, but I can look at those for the misdemeanors. I believe you're correct.
Yeah, I hadn't gotten there yet. It's a long rule. Okay.
There's a lot in there. Yes.
Yeah, I'm not seeing it because I remember this. This was a sticky wicket some years ago.
I'm not seeing those misdemeanor offenses listed either.
No,
I'm not
right.
either, because here's my recollection, Ken, which is why I asked the question. I think it's probably been 4 or 5 years since a new animal crime came before the commission. And as I recall, a number of commissioners then expressed frustration that it wasn't a person crime because it was an animal, not a person. And we debated that for a little while, but we wound up not putting, as I recall, that new misdemeanor as a person crime because none of the other animal offenses, unless they had the exacerbating facts that you just described involving people. And
I think you're right. I mean, and those aggravating factors are so sorry. So what I was trying to differentiate is that perhaps what the decision is here is that the misdemeanor remains not a person crime, which is consistent with what we have in our rules, but it's only the felony that gets ranked as a person crime, because to get to the felony level, you have to have those connections to either abuse of an individual or doing it in front of a minor child. So I think that's what I was trying to get at too.
That's what these two are. These have that connection.
Right. Yes.
That are on the screen right here, because I'm not.
Yes.
Maybe I'm just not seeing that here in the summary.
Right. I think in terms of how we wanted to present the summary, it is certainly within your power and the purview of the commission to rank both the misdemeanor and the felony as a person crime. So I think as staff, we did not want to lead you down one road or the other, but certainly the way this discussion is going, I think that it's consistent with our past practice that the misdemeanor be left without that designation, but perhaps the felony could have it.
So now I'm confused again.
Okay.
So does these amendments, it's described as amendments to the crime of animal abuse in the first degree, Class A misdemeanor. If someone has prior convictions, it may be a Class C felony.
Right.
That's just having priors. Or are you telling me that this is an incomplete summary and this involves people?
No, you are correct that you could get to the felony either way. So that you could get to it simply by having multiple misdemeanors, or you could get to it by having these aggravating factors.
Okay.
I worry that I'm mishearing your question or misunderstanding rather.
So let me back up then. It's my understanding, correct me if I'm wrong, because again, it's been at least 10 years since I've been an elected DA prosecuting these types of cases. But it's my understanding that animal abuse and animal neglect, not involving any complicating factors of intimidating a person or anything else, just straight up animal abuse and animal neglect, is not currently a person crime in Oregon. Is that correct?
That is correct.
So the amendments we're being presented with here, because I haven't looked up House Bill 4043 yet, which I probably need to do, but I was trying to scramble to get to the rules. The amendments here, the first one I see in blue, enhances the Class A misdemeanor to a Class C felony if someone has prior convictions, or is there more nuance to it?
Yes, there is more nuance, and so that is yeah, that is missing from this chart, that you can get there by having the prior convictions, or you may let me see, it's been prior convictions of one more.
And I'll call up the bill too.
Yeah, sorry. Let's see. Okay, so the changes that were made, and I apologize for the lack of clarity here, was first the actual standard for aggravated animal abuse in the first degree was changed in and of itself. It used to require that the individual would maliciously kill an animal or intentionally or knowingly torture an animal. However, now the person must intentionally or knowingly torture, cause serious physical injury or death, and there is essentially a defense if the person can show that there is a practice of good animal husbandry. However, that is straight up what you would need to demonstrate aggravated animal abuse in the first degree. However, to get to the felony level, you would have to have prior convictions for assault, those crimes that were listed by Rachel, if the offense was involved in domestic violence, or if the person knowingly commits the animal abuse in the immediate presence of a minor child.
And I'm looking at the bill as well, and I would agree with that.
That's section
assessment.
4.
So that tells me the first part is not a person crime, but the second part is.
That would be, well, it's not my vote, but that would be my impression as well.
Thanks. I don't have any further questions.
Talking to myself again. Can you hear me?
Yes, we can hear you, Paul.
Okay, great. Thank you. All right. So Rachel, you're looking for consensus on this. If I'm understanding kind of the conversation and where we are now, it sounds like this becomes a felony based on prior criminal history of assaults and or the presence of a minor when the act is committed, which would make this a Class C felony. And so are we being asked to designate if this is upgraded to a Class C to make this person crime, or would it automatically become a person crime if once it hits those aggravating factors?
we are asking that that it could be designated a person crime. It's not an automatic designation. So that's what needs to be considered.
But we're just talking about the aggravation. We're not talking about the actual misdemeanor crime, correct?
Theoretically, you could be. It sounds as though from the discussion with Vice Chair Bovet and Ken that in the past, the misdemeanor was not designated, something similar to what the current misdemeanor is, was not designated as a person crime, and those crimes that are similar to the aggravated, which you were referring to, has been designated as a person crime.
Okay,
but you do have the choice for both.
Yeah, okay, makes sense to me. Go ahead, Commissioner Norton.
So then that leads me down the question, if I'm looking at the laws correctly under section 4, the commits the crime of aggravated animal abuse. If we consider this a designation of a person crime, any of these could conceivably be considered a person crime, even if it's, don't get me wrong, I don't believe in torturing animals, but even if it's torturing of an animal, which is new, right? The bolded information is new. That could be considered a designation of a person crime versus something done in conjunction with domestic violence or like with a child present. Do you understand what I'm asking? Like, is it an all or nothing approach under the aggravation part?
Ken?
In this, so, okay. I apologize. This is why these ones are always so much fun, because they are complex, and I'm kicking myself for reading this very thoroughly a month or two ago and only briefly this morning. So for aggravated animal abuse, going back to my questioning by prosecutor Bovet here, I have to redirect my testimony ever so slightly. So aggravated animal abuse is always a felony under 167-322. It is a crime category 6 if you commit aggravated animal abuse simply because you torture an animal, or you cause serious physical injury or death to that animal, and it's not part of a practice of good husbandry. It is a 6. However, it is a 7 if you do it in the presence of a minor child, or if you have a prior conviction for some of these other person crimes. So the differentiation is really between where the level is on the grid. And so the way that we're talking about it right now, I think that the discussion we've had, the whole thing would be a person crime. However, I would note that you all as commissioners have the ability to essentially put any caveats on that that you would like. You could say it's only a person crime if it's a crime category 7, in theory. We don't do that very often. We have done it in the past where we've parsed out certain aspects of behavior to say that that is what is required for it to be a person crime. I'm not advocating for that there. I'm just wanting to make sure to define the authority that you all have when laying this out in rule. And I see that Commissioner Bovet has raised his hand, and he might have some more historical context for that too, or something else to add.
Thanks, Ken, for giving us another option and making this even more challenging, but just joking. Go ahead, Vice Chair Bovet.
And I hear Ken's concern about creating another way to carve these things out, but I don't think we have to, because the legislature did this. I'm looking at sections 3 and 4 of enrolled House Bill 4043 from this year. And I think really the crime category 7 in section 3, which is the animal abuse in the first degree, 167-320, is all baked into subsection 6. So I think we just have to refer to subsection 6. That is the CS7. And then as for 167-322, which is section 4 of the bill, I think all we have to do is refer to subsection 4. Again, that is the CS7. So I think if we just make a subsection 4 violation of 167-322 or a subsection 6 violation of 167.320 person crimes, then I think, unless I'm reading this bill wrong, I think we're actually plugging it in correctly, or at least within the rubric of how it currently exists.
I would agree with that from a technical standpoint.
Okay, anybody else that sees it differently? All right, so I think we have our consensus there. Rachel, are you clear?
Yes, yes. If it's,
If I can just add, the questions in your far right boxes would be yes and yes.
okay. Perfect.
All right, I'm mindful of time. How much more do we have to go on the sentencing guidelines?
I have 2 more slides. One of them is just really a recategorization. So it's a notification for you all that we are changing how to categorize some of them as we amend. And this one is also, this was flagged for us. These are some older crimes potentially to consider. They are all registerable sex crimes that are not currently classified as person crimes. And so we just wanted to, because they were flagged for CJC to consider, we wanted to present them to you all as considerations as possible person crimes.
Go ahead, Ken.
And I would just, so for these 3, just for a tiny bit more background, our friends at the parole board reached out to us, and they were looking over the list of registerable offenses and which ones were classified as person crimes and which ones were not. And they merely viewed these as being slightly inconsistent with the fact that other registerable sex offenses are person crimes. And so they flagged that for us, and they just asked us as staff to bring them up to you commissioners. They may have been, we don't have any records that indicate whether these were oversights or whether there were reasons to not include these back when they were passed, but we wanted to flag them for you since it was brought to our attention.
Okay, go ahead, Commissioner Bovet.
Pure speculation on my part, but in the past, sometimes the commission has chosen affirmatively to not rank and or classify because it's too fact dependent. And I don't know if that applies here. My guess is that the bottom 2 would almost always be what I would consider to be person crimes, and the top one might or might not, depending upon the facts. But I don't know. I wasn't around when these were classified.
Commissioner Auxier, do you have thoughts?
I would vote to, my thinking is that all 3 should be person crimes. Just based on some of the statements I made earlier. Same logic.
Commissioner Freeman?
That's exactly where I am.
All right, is there general consensus? Who is it? Another hand up? Oh, I think that's Commissioner Freeman's hand. Maybe if we can just do a quick consensus check. Commissioner Beach?
Yes.
Commissioner Norton?
I am for the bottom 2. The top one I feel is more fact dependent, but that's kind of just where I'm at. It's not a strong feeling, but that's where I'm at.
Yeah. Commissioner Bovet?
I'm with Commissioner Norton, but I'm willing to go with all 3 of these being the default to a person crime. I think that's probably the correct answer. At least that's my take.
I feel the bottom 2 clearly. I guess I need to, the sexual assault of an animal is, while very disturbing, I think really does depend on the circumstances. So I would be inclined to go with the bottom 2. classifying them as person crimes. So we've got three. Go ahead, Commissioner Norton.
I was just gonna suggest that maybe is this time sensitive that we could maybe take this up at a future meeting or get some more information on the first one?
Yeah.
And so that we don't have to decide today, but we can bring it back, because I'd like to do some more thinking on it. Yeah, that's kind of where I'm at with it.
Rachel?
For just the first one?
Yeah.
Okay, yeah, we can do that. We can bring back more information on just the first one. Just to be clear though, the other two,
Yes.
there's
There's
a consensus. Okay.
That's right.
Okay.
Commissioner Freeman?
I'm fine to do that, but maybe my math was different than everybody else's, but I think there was consensus for all three. A couple of people said they didn't care, so depending on which way you count those.
I think there were 5 votes and 3 of us. At this point, I don't think there's any harm in getting additional information. So let's go ahead and do that. We'll bring it back at the next meeting. There is clear consensus on the bottom 2. Let's move forward with those.
Sounds good. Thank you. And then like I mentioned, this is just a simple change that we do want to flag. If you look, the ORSs, for instance, it was 475B. It was flagged to us to change it to 475C for all of those. So just a notification that when we do modify the rules, we will be making those changes as well. So.
Great.
And I believe any sort of motion, I don't know if there has to be an overall one. I think for the most part, we did get consensus as we went. And so Chair Solomon, I will leave it up to you. But for next steps for us, we will take all of the changes that you all gave feedback on, as well as bring back that one specific registerable sex crime that you need more information on going for the next meeting.
Great. All right, let's jump quickly into our burn JAG funding request. We have about 30 minutes left. We also have 2 small agenda items. If we could maybe cover this in 25 minutes, that would be great. And I believe Kathleen and Susan, are you going to tee this up for us?
Yes, can you hear me?
We can.
Great. Okay, thank you so much, and thanks for having us back. So I'm Kathleen Carlson. I'm the faculty lead of the Gun Violence Review Commission for Multnomah County. Susan is our senior research associate who works on this project. We also have Alexis Ratamuga with us, who is the project coordinator. And then we have 3 commission members who joined us today too, who you can see here on the screen. We have Roy Moore from Portland Opportunities Industrialization Center, Yolanda Gonzalez from the County Health Department, and then we have Lieutenant Matt Clay from Gresham PD joining us today. So thanks so much. We got to share with you a few months ago on the progress of the commission development. And at this point, we've now completed a full cycle of reviews and recommendation development. So thank you for having us back so that we can share some of the outcomes of the full process, and also make this request for 1 more year of funding for now to keep this work going and to see it through to its fruition. Let's see if I can share. All right, do you see my screen here? Great. Okay, now I'm just trying to get you guys back. Here we go. Okay. All right. So we described our work before of establishing this commission. Just to provide a little more context, this process has been used across a lot of public health issues that are quite complex, including domestic violence reviews, child fatality reviews, elder abuse reviews, and so on. And we're seeing it more and more in overdose fatality reviews, and then in gun violence or homicide reviews like ours is modeled after. So the idea is that by examining the circumstances that lead up to the violent events, as well as the broader life circumstances like major health events, childhood trauma, social and economic and educational disadvantage among those involved in these events, encounters with law enforcement, or even environmental factors in the area in which the events occurred, that our commission members begin to see patterns of need and opportunity within and across agencies that have been involved with the individuals involved in these events. And just out of interest, we wanted you to know that the National Institute of Justice, so the DOJ's research, development, and evaluation arm, has given the homicide review process a categorization or designation as effective, which is based on a rigorous evaluation study of the Milwaukee Homicide Review Commission in Wisconsin, which found a statistically significant 52% decrease in the monthly count of homicides in their intervention districts, compared with a 9.2% decrease in the districts in which they weren't intervening. So we have the good fortune of being close collaborators with Dr. Connie Kostelek, who has led the commission in Milwaukee for many years, and she's been guiding us and providing mentorship on the development of our Multnomah County Commission here. So previously we showed you where we were. We were up here more in our cycle, and now we're down here in this toward the end of the cycle. So we have held review commissions monthly for the first part of this year, in which commission members reviewed in detail the life circumstances and violent events of several cases each of these months. The commission members then got together in person in April to really dive into the themes that were emerging across all of these reviews, and to start to pull together recommendations that were kind of bubbling up out of these themes. So we're here now working with all of these recommendations that they came up with, and kind of sorting and consolidating them, and clarifying with the commission members what it was they meant in regards to each of the recommendations, so that we can then hand them off to the implementation team, who will then work to begin to implement those changes. So this is the implementation team, is our team of influential, inspirational change makers who are out there working on this issue, or care about this issue, and are passionate and ready to work with the recommendations to make changes. Okay, so we're so fortunate to have assembled this impressive group of commission members that you see here. They're very engaged in this process, and that makes us very optimistic about how this is all going. So we have individuals from each of these entities representing kind of these broad categories up here. Also city agencies, state agencies, and healthcare institutions. This is our implementation team so far. We still have a few invitations out for leaders that would be on the implementation team, but you can see that we've involved community leaders, so that the leaders of the most heavily affected communities will have buy-in to these efforts to implement changes. We have county agencies represented, state agencies represented, including the governor's office, and also city agencies represented. So moving on to outcomes, and first, just from the good fortune of being kind of the backbone organization or organizers of this effort, and being able to see the commissioners in the process of doing their work. It's been fascinating and really heartening to see some of these big picture outcomes coming out of the work. So just first and foremost, establishing this multidisciplinary group of individuals and organizations who usually have their own unique perspectives on violence and the gun violence issue, all coming together under this kind of umbrella of public health with this public health lens to look at health effects on the likelihood of violence and the health outcomes of violence as well. And they're doing this with a view or a lens that's unique to our county and to our state. Then this group is coming up with this comprehensive set of recommendations for prevention that has the support of this broad constituency of across all those commission members of different types or different backgrounds, different disciplines, as well as the members of the implementation team. So this is something remarkable to us because it hasn't been done before in our region. Third bullet point here is the sharing of data around violence and gun violence and other adjacent information among or between these organizations that don't typically share data. And the trust and the ongoing communication that's being built between commission members as a part of the sharing too. So kind of breaking down the silos that we all are tending to work in as we're addressing violence and getting greater communication across these silos. Partnerships, new partnerships is part of this, and I can just give an example there. A commission member from the County Department of Human Services, who serves as the manager for the Domestic and Sexual Violence Coordination Office, has reported to us that they are now coordinating with the Suicide Prevention Coordinator and Postvention Response Lead for the Behavioral Health Division of the Multnomah County Health Department. He also said he's meeting now with a commission member who's the executive director of the nonprofit Holistic Healing Behavioral Health Care, which offers community-based, culturally specific behavioral health services to individuals and families in the metro area. And along those same lines, we also heard from our community member from Love is Stronger, a CBO that provides support to gang-impacted families, who's been referring people now to Holistic Healing Behavioral Health Care for the first time. Finally, this bullet point here, we have gotten a lot of media attention around the review commission and for better or for worse. But really the better part of this is that it's been giving us the opportunity to improve the public's understanding of the root causes of gun violence and perhaps help shape the media's reporting of the gun violence issue and highlight all the people in the organizations that are working to address it. Okay, some of our early outcomes, we ask that these stay kind of as draft form because we're still parsing out some of the language and haven't made these public yet. But what's been showing up so far is a real focus on early intervention in the education and criminal justice systems. So proactively offering coordinated and pro-social, culturally specific opportunities and services to students and families. Commission members talked about how traditional conflict resolution that's often called for doesn't really work with the population of kids who they know to be at risk. And also that school districts, schools, embedded within school districts and then embedded in counties are all kind of doing their own things around prevention work for these kids with a lack of coordination across efforts. And so we talked a lot about families who are at risk, who are moving in and out of these schools and even in and out of school districts or across the counties, and the need for kind of wraparound of these children, so the coordination that can provide wraparound for these children. Second recommendation is similar, and that's providing culturally specific training for the judicial department. And this was actually a recommendation that came from a breakout group comprising a judge, a law enforcement officer, a public defender, and a deputy DA, who talked about this need for culturally specific training in the judicial department that really focuses on family dynamics, domestic violence, substance use disorders, and equity. Okay, another recommendation that has come up multiple times is this a need for increased cooperation and coordination among CBOs, among state and local government agencies and departments, and then between the CBOs and those state and local agencies. And one major task that's been identified as underneath this kind of umbrella recommendation is the need to reorganize and expand countywide Office of Violence Prevention, or a countywide Office of Violence Prevention for the county. So expanding what we have there now to better coordinate gun violence prevention work between the city and the county itself. I'm going to try to move along quickly so we have enough time for our commissioner members too. Substance abuse comes up in almost all the cases that we've reviewed. And so some of the early recommendations around this so far are expanding integration of federal partners with local law enforcement and using federal funding to increase their visibility, reduce drug supply, and address cartel activity. And then also working with the OLCC to use liquor licensing regulatory authority to help increase the enforcement of precursor activities like drug distribution and gang activity. So there was also talk about the OLCC using their authority to try to avoid creating the environments with a high density of outlets, of substance outlets in these neighborhoods that are most impacted by gun violence. So we tended to see this a lot when we were examining the built environment or even the locations of the gun violence events that we were reviewing had to do with substances and these outlets that were located within these neighborhoods that were highly affected. And investing in communities with sustained funding. So one idea under that category was offering opportunities for homeownership among low-income families as an alternative to what we're seeing among these impacted families is living in the low-income housing developments that can be hotspots for gun violence. So commissioners called these trauma zones. So families who otherwise may not interact with each other or may have intergenerational conflict that are then pushed out and into these housing developments. And our commission members see a need and a possibility for home ownership for these families instead. And the other one here is encouraging state and local funders to make expanded and sustained funding more accessible to community violence prevention organizations. So this really comes out of the CBOs that are represented on our commission who really struggle to sustain their funding, even though they're showing promising results. But there's scarce funding and they're often pitted against each other to apply for the scarce funds. So changing the environment so that the CBOs can be working together and that they can rely on sustained funding over time would really help build these prevention efforts that take time and sustained coordinated efforts. Reducing gun access by unauthorized or high-risk individuals is, of course, a common thread that comes up. A couple ideas here focused on straw purchase investigations, supporting a nationwide expansion of the integrated ballistic identification system, and then even looking at incentives for gun disposition that are culturally sensitive, and education on secure storage to keep firearms out of the hands of unauthorized individuals. And finally, there's been a lot of talk about expanding victims assistance. So members explain that it's difficult for a survivor to get services if they have not filed a restraining order. And so providing access to social services and support and preventive services for domestic violence survivors without stringent requirements is one idea they came up with. And then also expanding eligible use of victims assistance funds. So we have parents on the commission who've lost adult children to gun violence. We have survivors of gun violence who've lived in that aftermath of a shooting, and then also the many CBOs that we're working with who work with victims and their families. And they've all discussed expanding the use of the Victims Assistance Fund to include more than just the burial expenses and include meeting the basic needs of these families, especially if a loved one who was killed is the one who was a primary earner for a family. How can we help that family stay on their feet in the aftermath of this shooting? So there was a lot of talk about how logistically difficult it can be to access these funds, and ideas that emerged from that conversation about how to break down those logistical barriers for the victims who need it. Okay, I'm going to turn over to you, Roy, to share your insights and experiences so far. And then we can have you hand it over to Yolanda, and then Yolanda to Lieutenant Clay.
Thank you, Kathleen, and good afternoon, Chair and Commissioners. Thank you for your time and for letting us speak to this issue today. My name is Roy Moore. I am the co-director of the Community Care Team with POIC, Portland Opportunity Industrialization Center. I co-direct the Community Care Team, in which we do everything gun violence. So I have a team that goes to the hospital. We're on call 24/7. We're embedded in all the community violence that we're experiencing. So you might see my team in the community at events, at crime scenes, at funerals, at vigils. And full disclosure, I am a survivor of gun violence myself, a former gang member. So this work is near and dear to my heart. And it's also my passion, and I'm moved when I see work being done. You heard Dr. Kathleen Carlson use words like silos and trust. I've been doing this work for 7 years, and what I can say is there's too many silos and not enough trust. So any forums that bring people together for us to address them, I'm all for, but this one is unique because we use a public health approach. And when we look at violence through a public health lens, we understand that it's treatable like a disease. It's spread, but we can also take a deep dive and look at it almost from a scientific lens. And that's what this commission does. It brings people together, several different entities together, take a look at a case, and we're able to identify gaps, trends, where we dropped the ball at. And I sit in a lot of meetings and a lot of committees, but I don't have the opportunity to have a brain trust to take a look at where we failed, but also where we can be better at. So this commission provides that. And I wish that I had more opportunities to take a look at where factors played a part in where that trajectory of that person's trauma or the violent act that occurred to them. This commission brings together law enforcement, community-based organizations, people from the healthcare field, and we're able to look at each individual case and to talk about where was I at? Where were you at? What do you know about this person? Where did we drop the ball? And then find data points so where we can correct, but also take a look in the future to address gun violence. So I want to continue this work with this commission. We're doing great work. So I encourage you, please, to fund this and to take a look at this as we address gun violence. It takes more than one entity, and this brings together lots of different organizations and people to the table to address gun violence, not just in a county, but statewide. So thank you, Kathleen Carlson, and I'll pass it on to Yolanda.
Thank you, Roy. Good afternoon, Chair and Commissioners. My name is Yolanda Gonzalez. I am a licensed clinical social worker, and currently I serve as the Senior Manager for Direct Clinical Services in the Behavioral Health Division at Multnomah County. Previously to coming to the county to oversee the children, youth, and young adult mental health programs, I worked a lot actually in the community with Roy and doing, I was a clinician and a therapist providing services to families who had been impacted by gun violence and were systems involved, as well as designing and managing programs that serve those same families. I'm also someone who has personal experience losing loved ones to gun violence. This is also near and dear to my heart, as it is with, I feel like, everybody who sits on this commission and review. I'm here to speak on behalf of the Gun Violence Review Commission hosted by OHSU and the amazing work we've been able to do to date and the impact I believe it can have if we're able to continue this work. The commission has been able to pull together partners in a way that I haven't seen in my career. across systems, bringing professionals and those with lived experience out of silos and together with the hope of creating solutions, responses, and policy change. There is a hope, and I say that word a couple times because I actually haven't seen a group of folks this invigorated with hope around a topic that's so traumatizing and can feel defeating. There's a hope that has risen from the commission, and that I feel that when we come together that I haven't felt around the topic in a long time. OHSU provides a really unique experience by hosting it too, because they provide data sharing agreements in place. They've been able to do something I can't do in the government world, is create these data sharing agreements across multiple systems and do so in a quick manner. And I don't think that's a small accomplishment. I think it should really be celebrated because it's really challenging to get. I feel like I'm amongst lawyers, so I don't think I'm in good company in understanding how hard it can be to get data sharing agreements across systems. And so I just wanted to celebrate that today in front of you all. I also think they are positioned well to host the commission because they use data-driven, trauma-informed, passionate commitment to support changes for healthier communities by using the public health approach. The commission is driven to understand our unique community needs, strengthen systems, and create sustainable policy change that will create healthier communities. There's a targeted goal here, and I feel like everybody can get behind that. Together, we look at cases and see where systems can be improved to prevent future deaths and incidents of gun violence. I've seen successful interventions come out of other review commissions that I sit on, like the Child Fatality Review, and I'm hopeful that for the preventative and systemic change that this commission can have on a topic that is complex and what our community deserves and needs. I don't know if you all know this, but gun violence has surpassed car accidents and is now the #1 cause of death for children in the United States. I have a huge passion and commitment to serving kids and leaving this next generation better than I found it. And so this topic is not, it needs the attention and it deserves the attention because kids deserve better than dying by guns. I support the continuation of the Gun Violence Review Commission and wholeheartedly believe in what it will take, a data-driven cross-systems approach with the voice of those impacted to lead change and create outcomes in our community as it is related to preventing future injuries and deaths due to gun violence. Thank you. And I'll pass to Lieutenant Clay.
Hello.
Hello, and Lieutenant, we've only got a couple minutes left, so definitely want to hear from you, but just want you to be aware that we're running out of time.
Sure. It's an honor to be here talking to the commission. I'm the commander, the investigations commander for Gresham Police, so I'm in charge of all the detectives and that kind of stuff. To give you some context, we average about 500 plus reported shootings a year. We're able to confirm through damaged property, injured people, and shell casings about 159 a year. And we had 6 homicides last year by gun, 9 homicides total in Gresham. That's not to include our child abuses and stuff like that. So participating in this commission has been eye-opening for me, getting to be exposed to all the other organizations and people fighting this fight, hearing about their challenges, because we always complain about our own challenges and how we're dealing with this and how we're responding, but to hear everybody else's challenges too and what they're trying to overcome. I'm hopeful that this approach is in the process of uncovering new considerations and strategies that we haven't been doing, because what we've been doing hasn't been working. I'm especially excited from a law enforcement standpoint because we just respond. We don't have a lot of proactive strategies in law enforcement. And with our staffing challenges in Gresham, we don't have officers in schools anymore. We don't have a gang unit anymore. We don't have a lot of resources that we used to have. So finding another approach, finding new insight is really exciting to me. And I've enjoyed working with this wide group of people and wide group of experiences and figuring out a way to not just respond, but do something proactive to help stem the violence because it's overwhelming our resources.
Great, thank you.
And that was all that we had. We were thrilled that our commissioners could join us to talk with this commission. Thank you all for being here. And if you have any more time you can afford us and have questions for us, then Alexis, Susan, I, or our commissioners can answer any questions.
Well, thank you all for your time and presentation. Really appreciate it. I think we would like to move now directly into our conversation about whether or not to approve your request. So in the meeting packet, commissioners should have received a summary of the budget request that was submitted. Recognizing we don't have a lot of time, are there any specific questions that commissioners have that they would like to direct to members of the commission at this point? Commissioner Freeman.
So when you're ready, I'd like to make a motion to approve the request or the recommendation from staff, I guess is what I should say.
Yeah.
So if you're ready for that, I'd do it.
Okay.
And I do have a comment I'd like to make though.
Okay, I have one question before we actually move there, and that is around the indirect cost. And staff, can someone tell me what the policy is around indirect costs and whether there are limits to how much the commission will pay in indirect? Ken or Ian or anybody? Because I noticed that they've got almost about 25% of their request is in indirect.
That's a great question, Chair. Gerardo, I know that you're listening. You oversee our federal grants. Since this would come out of JAG funds, would we need to limit this to 10%, or do we have more flexibility there?
Hi, Ken, and hello, commissioners. I don't think there's a limitation on the indirect. I think if it's something they already have negotiated with the federal folks, I think we would be able to use that indirect. But that would be something I would have to look further into. But right now I believe their indirect would be fine.
Okay. All right.
But and perhaps the motion could include an approval, but then it could just have a note that we could make sure that it's within the requirements of our federal burn JAG grant.
Okay.
For the indirect.
Great.
Hi, this is Danielle Topinski. Hi, everyone. I'm just looking at the JAG solicitation, and I believe as long as they have a negotiated indirect cost rate agreement, that would apply.
Do we have a negotiated?
It wouldn't be for us. It would be if the subaward is with OHSU, it would be their negotiated indirect cost agreement. If they want to apply their 25% rate to their budget.
Okay, I'm still unclear on what that means. Negotiated with who? With the federal government?
It's a federal document, depending on whoever their overseeing agency is, that they get an indirect cost rate that they're able to apply to federal funding. And if they have that agreement and it's the rate specified in the budget that they proposed, then that would be okay. We would need to attach that indirect cost agreement to the award modification application for the JAG funding.
Okay.
So yes, it is permitted.
Okay, that's
under
helpful.
the solicitation.
Ken, did you have another comment?
I was going to give that basic information as well. Universities regularly negotiate cost agreements. I have actually just pulled up OHSU's agreement. The thing that makes it more complicated when we are already over time is that there are a number of different indirect rates depending on the type of services being provided. Yeah. And so I think, again, this is something we could make sure to work out at a staff level if you all approve of the overall project, just to ensure that we're within the appropriate levels as required by their rate agreement.
Okay. I appreciate that. Sorry for taking the time. Clearly, it's an issue that I have, having paid a lot in indirect rates over the years with researchers that we've worked with at universities. Yeah, so I'll just stop there. Commissioner Freeman, you were going to make a motion and a comment.
So again, since we're short on time, I'll be brief. I move to support the staff recommendation for the funding.
Great. So I'll take that as a motion. Is there
Yep.
someone who would be willing to make a second?
I'll second that. Commissioner Beach?
And a quick comment, if I may.
Please.
So I want to thank the group that's working on this, and I really appreciate that the presentation was focused on violence and the cause and the root causes of violence. I understand that it is a gun violence narrow focus, but if you don't fix the broader issue of what's causing violence, the instrument in which they use to create the violence and the deaths is going to be not as important as stopping the violence in general. So I really appreciate the presentation and hope you continue the effort on the root cause of violence, and we keep our focus on fixing the problem. So thank you very much for your work.
Thank you, Commissioner.
Right, thank you, Commissioner. All right, we have a motion made to approve the request made by the Gun Violence Commission for additional burn JAG grant funds in the amount of $269,155, made by Commissioner Freeman, seconded by Commissioner Beach. Can we take roll, please, Carol?
Yes. Chair Solomon,
Aye.
Commissioner Auxier,
Yes.
Commissioner Beach,
Yes.
Vice Chair Bovet,
Yes.
Commissioner Freeman,
Yes.
and Commissioner Norton.
Yes.
Then it passes.
Great, thank you. Commissioners, so we still have restorative justice grant program update, and it sounds like we can table the agency updates. Are folks able to indulge and stay for maybe 2 more minutes to hear the restorative justice grant update? Okay,
Can
great.
do.
Okay. And our team will hop off.
Super. Thank you so much.
Thank you so much for having us back and for another year of support. And we look forward to sharing more outcomes with you soon.
Look forward to it.
Thank you, everyone.
Yeah. All right, Casey.
All right. Hey, everyone. I will keep this as brief as possible while also still trying to give you the information that you need and not talk in a Mickey Mouse voice. So good afternoon, commissioners. My name is Casey Beck. I'm the Behavioral Health Program Manager at the CJC. Today is just a few quick updates on the RJ grants, total of 5 slides, including this one, and you're already done with this one. So moving on. As established by House Bill 2204 back in 2021, the Restorative Justice Grant came to be. The Restorative Justice definition is here. You may read it as I continue along for the respective time. There was $4 million appropriated back in 2021 as one-time funding for the RJ grant, and that was distributed to grantees. And in House Bill 5204 from this most recent session, there was an additional $4 million appropriated to the RJ grant program for use in this biennium ending in 2025. So the Restorative Justice Grant Advisory Committee met at the end of April and talked about that additional funding and what they were hoping for the RJ grant and its future. They decided to prioritize the existing programs as well as open a planning grant opportunity to new applicants. The reason that it wasn't a full solicitation open to everyone was just because of being mindful of such a short time frame. This funding has to get out the door and needs to be completely allocated and relatively spent by June 30th of next year. So really, it's a very quick timeline to get new programs up and going. The Grant Advisory Committee was mindful of that, and this is what they chose to do. They allocated up to $3 million of the $4 million to existing grantees to maintain their current operations for an additional 12 months through June 30th of next year. And depending on how much those folks actually needed, there would be at least $1 million available to new applicants for maybe 6 to 9 month planning grants, just opportunities to get folks together and talk about developing new programs and understanding the needs of local communities. A short form application was open to existing grantees for that up to $3 million amount back in May or earlier this month, really. And all 7 existing grantees opted to, yes, extend their project periods for an additional year and request additional funding. That total amount requested came in a little under the $3 million. Just they were very mindful about addressing their needs. And that means that the remaining unallocated funds is about $1.3 million. And so today, just wanted to give you all an update of next steps. The Grant Advisory Committee will be convening again on next week, June 7th, to review those applications received by those grantees to understand what requests they actually have regarding that funding, to make those approvals, and then to discuss those next steps for those unallocated funds. Will it be all open to planning grants? Is there going to be maybe a capacity building opportunity for existing grantees? To be decided. And then I'll be back here with you all on June 26th at the commission meeting to give you an update on what those decisions were and ask for your action in authorizing those awards. My last little update is just that we are welcoming a new member at the upcoming Grant Advisory Committee meeting, and we are working to fill 2 vacant seats. One for an individual who was previously incarcerated and one who is an individual who is a member of a tribe. So hopefully that wasn't too Mickey Mouse voice, and I am available for any questions you have.
Great. Thank you, Casey. Commissioners, any questions? All right, well, we look forward to seeing the applications at the June meeting and hearing more about the process for allocating the unallocated funds. I think with that, we can go ahead. This isn't an action item. We can go ahead and wrap up. Really appreciate everybody's indulgence and staying on for a few extra meetings. I start to twitch when we get over the time, so I like to keep us on track and out of here, but we were able to get the majority of our work done. So with that, unless there's any other business, I think we can go ahead and adjourn. Thank you all.
Thank you.